Yeah, now Wally, that's it. Now we are here. We share again about self, but we're not in it. You did bring your brain, so still, I said, the only what you saw, so we're not there. Obia to a drana, and now one on your what you saw, so we're in the more because we're for Massa. Okay. Why are dear Panyamin Chiauka? Oh, your days is an amami. You are Posano Abasa. You know, the only man is on it. Boys, Shalabadi, Namachika, Namuchiko, Tishatayana Wale, Nawunya Wale, and Mawa form, dear Siakabe. A man that no habit, never tell Krakachin Tistate, Manu and Bo Dream Abredia, and Wale.
Tonight, lawyers for John Mahama demand accountability from EC chairperson as they plead with the Supreme Court to compel Jean Mensa to submit herself to cross-examination.
The petitioner has not filed a witness statement.
What is more grave than a petition? What is more serious than a pleading? And a witness.
My lords, it's not a question of what is more serious. It's a question of what the rules are. In no of it, the petition.
I'd like to say, Mr. Chikata.
Can I answer one at a time?
Very well, very well.
More of those heated exchanges between Chachi Chikata and the judges of the Supreme Court on the matter.
The holder of such a public office cannot be held to account by being cross-examined. Then, my lord, we would be posing grave dangers to the Republic.
And Top Story is always brought to you by Gasem Cement, the nation builder. Vodafone, the future is exciting, ready as well as Belaka Mineral Water.
This is Top Story with Evans Mensah.
It was another day of intense arguments at the Supreme Court, with lawyers for John Mahama demanding that the court compels EC chairperson Jean Mensa to account for how she conducted the 2020 general elections. Yesterday, in the ongoing 2020 election petition hearings, lawyers for the EC announced the chairperson will not be entering the witness box to testify and be cross-examined. Well, today, lawyers for John Mahama who had petitioned the court, made their case why she should be compelled, insisting it all boils down to holding the EC accountable.
In the situation that is before your lordships, what the clear interests of justice require is for your lordships not to allow the evasion by the chairperson from cross-examination. We're dealing with a matter concerning the exercise of grave constitutional responsibilities by someone who has been duly appointed to a high office of state. And that person, in my respectful submission, has a constitutional duty to give an account of what she has done in the conduct of her responsibilities. CI 127. CI 127 is under the hand of the chairperson of the Electoral Commission. And there is evidence before your lordships that she did not even comply with a CI under her own hand. My lords, if The holder of such a public office cannot be held to account by being cross-examined after she herself has given a witness statement. Then, my lords, with the greatest respect, we would be posing grave dangers to the Republic, because the holders of important offices can shield themselves from accountability by saying in every case that we will not allow ourselves to be cross-examined, and nobody can do anything about it.
Court correspondent Joseph Akablase with me in the studio. So that is a plank of Tachi Chikata's argument today. Did we hear anything from the EC lawyer?
In fact, Mr. Amenuvo, Justin Amenuvo, the lead counsel for the Electoral Commission, was actually the one who set the whole debate in motion, and he made a point that, as far as he's concerned, his understanding of the law is to the effect that a respondent can elect not to call evidence at a trial in a civil case. And he says if a witness has not testified and the person has filed a witness statement and decides at any point that he no longer intends to go into the box to be cross-examined, the court can then proceed to treat the witness statement as hearsay. And he cited a case, a recent 2012-2013 decision of the Supreme Court, to make the point that the court cannot compel such a witness to come into the box to testify and be cross-examined. I
see. Well, what about lawyers for the president? Because they've also adopted the same position that they will not putting anybody in the witness box.
Yes, Mr. Kutampao spoke to the court on the issue, and he actually cited an English case, because Mr. Chikata had earlier cited an English case to make the point that that's allowed for a person who elects not to, who has elected to testify, eventually say that I'm not going to testify anymore. He should do so timeously. And the point that Mr. Kutampao made with the case he cited was to the effect that you cannot compel a witness to testify.
To refer your lordships to the English case of Society of Lloyds versus William Otho, where the issue of a party failing or refusing to give evidence after a witness statement had been served on other parties in the suit arose, and a prayer was made for the witness to be compelled to enter the box. The court held as follows: where a party, after serving a statement of his witness on the opposing party in accordance with pre-trial directions, decided not to call that witness to give evidence, the court had no power to order that party to call his witness to give evidence in court. Unquote.
An authority has just been cited, and I respectfully wish to be heard on that authority. The one that has just been cited. Very well, but my lord, I wish to make submissions in respect.
No, you can't. I'm sorry. You can't.
Why?
The rules do not permit you to.
No, I'm asking for, my lord, I'm asking for leave. In a reply, he cites an authority, and I'm not allowed to comment on that authority. Yes, but my lord, why can I not be heard as to why that authority is not applicable? No, but my lord, it would have been fair if he had cited that authority in his main submissions. Then I would have had a chance to respond. But if he cites it in his reply, yes, but my lords will not hear me on an authority that has been cited and on its relevance. Is that, my lords, I will abide by your ruling, but is that the ruling of the court, that you will not hear me on an authority that's been cited in reply? Your lordships gave leave for him to reply and to cite an authority, and you will not hear me on the authority. If that is your lordship's ruling, I will abide by it.
Can you give him the authority? Can you give him the case?
My lord, I had no hesitation in letting them out.
Yes, you saw it. You passed the report.
Because that is the professional etiquette that we...
I know. That is why, Bishop, you do have it.
He has cited...
I even asked that if it is possible for him to make...
My lord, I'm not even seeking to have what they have read.
Yes.
I'm seeking to be heard in response to what they have heard. And without hearing me... So, my lords, my respectful submission is that the circumstances of this case are completely different from the circumstances of that English authority for two simple reasons. That authority is not about the holder of a constitutional office.
So this is just an example of that heated exchange, the banter, if you may, between Chachu Chikata and the judges of the bench. This one was in direct reaction to Akoto Ampah, who had finished submitting his case against Chachu's position that the Madam Jean Mensa must be compelled to account in the witness box. This was just a tip of the iceberg, because for a significant part of the day, it was really Chachu versus a lot of the Supreme Court justices on the bench.
Mainly Professor Kote, Justice Gertrude Tokonu, as well as Justice Mafosau, who had a lot of questions, especially on issues relating to the civil procedure and whether or not such an individual who has said, "I'm not going to testify anymore," should be allowed to simply walk away from the box.
After signing that, she also signs a number of affidavits.
So, Mr. Chikata,
and so
the petitioner in this case has signed a petition.
yes.
Can he be compelled to come and give evidence?
My
The
lord,
petitioner.
who will compel him?
He has almost deposed. He has almost deposed to all the affidavits from
But
your
my
side.
lord, that is not the point. Who is going to compel him?
What is good for the petitioner issued the
Petitioner has
petition?
not filed a witness statement.
No, but
Has the petitioner
he
filed
has,
a witness
he
statement?
has
in this
filed
case?
a petition. He has deposed to several affidavits. Can we compel him?
The petitioner has not filed a witness statement.
What is more great than a petition? Mr. Gita, what is more great? What is more serious than a pleading and a witness
My
statement?
lords, it's not a question of what is more serious. It's a question of what the rules
No,
are.
I'm-
In no affidavit of the petitioner does she say what I'm going to be subjecting myself to cross-examination, and therefore you don't need to serve me interrogatories. Nowhere has she done as a petitioner.
Chikata, I'd like to say, Mr. Chikata.
Well, can I answer one at a time?
Very well.
Yes, my lord, the petitioner has nowhere said that I am going to present myself to cross-examination and then reside on that. The petitioner has never said that. In fact, the petitioner has not filed a witness statement. The petitioner is relying on his witnesses, which is entirely allowed. So, my lords, nobody can compel him to come and testify. And what the point that I was making in respect of what is in the affidavits of this chairperson is that she herself, in opposing an application in respect of serving on her interrogatories, she deposes to the fact that she is in effect going to be available to be cross-examined. She says that. I read the affidavit. There's nothing equivalent to that in the affidavits of the petitioner. Nothing. And there cannot be a legitimate comparison between the status of the petitioner and the status of the chairperson on the basis of that. That cannot happen.
So, Mr. Skata, all that I'm saying is this. If a party comes to court and informs the court that he's going to give evidence himself and call 3 witnesses, and later on he changes his mind that because of certain things that are happening, I don't intend to lead evidence, neither do I intend to call witnesses, is the party bound? Or can the court compel that because of the statement that he made?
My lord,
can he be compelled to testify?
My lords, what I've stated clearly is that Order 36, Rule 4.3 is clear in its terms. Where the defendant elects not to adduce evidence, and so and so. And my lord, I have said that in this case, this first respondent, has elected, and he's elected both by filing the witness statement, and also he is elected by her affidavit.
She can't change his mind.
My lords, that's why I said if she changes her mind, there are proper ways to effect that. At the moment, we do not have that situation.
Order 38, Rule 3(5). Who deals specifically with witness statements? CR 87. Who deals with specifically with witness statements? And the interpretation that we can put on this, that witness statement.
Yes, my lords, the 5.
So the witness has gone to the witness box and taken the judicial oath.
My lords, with respect, that is an erroneous interpretation. My lords.
And please, Mr. Chikata, in your rate, really for the number of witnesses that the petitioner intends to call, 5. Eventually, you call 2, and then you, with leave of the court, you add 1. But were you going to insist that because you've written in your rate that you will call 5 witnesses, go and bring the 5 witnesses?
No, my lords, that is not the same situation. We had not filed 5 witness statements. We had not filed 5 witness. My lord, the matter is very clear. We had not filed 5 witness statements. So that analogy does not hold.
But I've already told you that, yes, the witness statement may be filed. But until the witness enter into the witness box and swear an oath, it is not evidence yet.
My lords, this is not the position that was taken by this Supreme Court in a case Sumaila Bill versus Adamu Dramani and the Attorney General.
So there you have it. If you missed it, this is just a snapshot of a lot of that, heated exchange between Chachu and the members of the bench. But there's a substantive point he makes in that banter, which he kept coming back to, which is that in the affidavit, position to their application to
review the
interrogatories ruling, he alleges that Madame Jean Mensah, the Electoral Commission, has stated in that document that, they would have an opportunity to cross-examine her, and so that interrogatories, application should be thrown away. Is that true, though? We've been checking.
Yes, and so I'm reading from a document filed by the Electoral Commission. It starts by the top part of it reads affidavit of first respondent in opposition to motion or notice for review, and it starts I Jean Adukwe Mensah. Then it gives the address among other things. Paragraph 7 of this document indicates the applicant does not suffer any injury to his rights if the court dismisses the review application, as he still has the opportunity to solicit the answers he seeks now during cross-examination if he so wishes, unless he is actually fishing and or trying to delay the trial. And so the EC chairperson in this document was saying that if you are not seeking to delay the trial, you will have the opportunity to ask these questions during cross-examination.
Very interesting indeed. And of course, the court is going to pronounce on all this when?
On Thursday.
On Thursday, okay. Thank you. And it has implications 2 ways. If the court decides to agree with Chachu Chikata, then Jean Mensah, the case continues. Jean Mensah gets into the dock and then, of course, continues. If the court disagrees with him, almost suggests that the case has almost come to a close.
It will mean that obviously the date would have to be taken for written addresses if the court allows to be filed, and afterwards a date for judgment. So that will be what will happen.
Okay. Joseph, thank you very much. Let me go on to the phone lines and bring in private legal practitioner Martin Kpebu. Joyce has been keenly following today. Who wouldn't? If you're a lawyer, you would, right? Joins us on the telephone line. Mr. Kpebu, thank you for your time again.
Yeah. Good evening, Evans.
Good evening to you. And just stay with me briefly because we just have some breaking news that just coming through from Parliament.
No problem.
Well, in the last few minutes, we are learning that Parliament has been suspended for 3 weeks due to a surge in COVID-19 cases. And if you're just joining us, that's the breaking news coming out of Parliament. The entire House has now been suspended for 3 weeks due to a surge in COVID-19 cases. I want to take a quick detail on this from my parliamentary correspondent, Parker Wilson, who is joining me. Parker, what more do we know about this?
Right, so Evans, the Speaker, when he was communicated to the members of the House, indicated that over 151 parliamentary service workers have been tested positive or confirmed positive with COVID-19 case. And as a matter of fact, it's important that they safeguard the lives of members of Parliament and, of course, those who work in Parliament. And so it will be important that they suspend the House for 3 weeks. They go home so that they can break the cycle of the transmission. Again, those will protect the members of Parliament and, of course, every individual within the parliamentary enclave. But then the vetting committee will be sitting. So this will give them an opportunity for them to do their work within the 3 weeks and also put together their report. And by the time they return, they believe that the vetting committee would have been able to put together their report, and then they will look at the matter. And so Parliament just adjourned, and as we speak from tomorrow, they are not sitting, with the exception of the vetting committee who are scheduled to vet the the ministerial nominees tomorrow.
Okay, Parker, just reiterate the numbers again in terms of the numbers of people infected in Parliament. How many?
Well, he talked about 151.
150,
service
151.
51, yes, 51, 51.
51, okay. This is parliamentary service staff?
Yeah, parliamentary service staff. Now, he didn't mention the members of Parliament. Before, we were told that 15 tested positive. And this morning, when we go to Parliament, we picked up information that there has been more numbers. About 17 of them have also tested positive. That's the information that we picked up. Right? But the Speaker did not disclose to us the members of Parliament who have tested positive for the virus, but rather indicated to us that because of the surge, it is important that they break the cycle of transmission and suspend the House for 3 weeks.
Parker, thank you very much for that quick breaking news coming in from Parliament. We have more on this on Newsnight in 8 minutes. Join us for that. The key development in Parliament tonight is that the House has now been suspended for 3 weeks because of a surge in COVID-19 cases in Parliament. As Parker just reported, a total of 151 members of the parliamentary service staff have tested positive for COVID-19. There is no indication yet how many members of parliament, but Parker indicated that it may be as many as 15 members of parliament who also may have been infected with COVID-19. So the House has been suspended for as many as 3 weeks. On that. That's a breaking news story from Parliament. I want to return to our top story, our main top story. It is from the Supreme Court, the petition hearing. Thank you very much, Mr. Kwebu, for your patience, and stay on the line with me as we brought in that breaking news from Parliament. I need to ask you, for us mere mortals who watch what unfolded today, clarify for me this long, drawn-out exchange between Mr. Chikata and the members of the bench, the judges, almost all of them, constantly, some asking questions, others arguing with him almost, and he pointing out to them that their position is erroneous. Is that normal practice?
The way to put it is this: you don't see that often. But our judges have shown that they are capable of taking very rigorous banter from Mr. Chikata, but it's not common. It's not common, but that's not to say that it's also not healthy for the bench. As I've stated a number of times before today, they have a relationship with him that you and I don't know much about. You remember there was even this day, Justice Tokonu said, Mr. Chikata, I eat from your home. Okay, does that mean that I should recuse myself from this case? And Mr. Chikata didn't say anything. Yesterday, remember Justice Mafusa, when they closed, Justice Mafusa, Mr. Chikata was trying to get his wig. Then Justice Mafusa reached out to him. Mr. Chikata, you don't need your wig. You don't need your wig, in a very playful manner. I could cite more and more of those. So, Evans, I think what we ought to applaud is that, yes, this is a very serious political case. Okay, it involves the politics of this country, and in that case, the judges are showing that, look, we just want to get to the bottom of this matter. Don't let it sound to you as if we are fighting Mr. Chikata. No. The very nature of our practice is such that you ask lawyers, you hear words such as this application is incompetent, it's frivolous, it's vexatious. It's just the nature of the...
But I have a question, though, on this. And this is on an education of us who are not used to what is happening in the court, right? I mean, because I wonder, these are judges. They are going to make the final pronouncement of what Mr. Chikata's arguments are. Whether they agree or not, they will pronounce on it. So what's the purpose of the in-court arguments with him when they will decide anyway? I mean, disagree with him, argue with him when they will decide anyway.
Well, that's rather even very healthy for us. So they are pointing out, each side is telling the other, look, we are not happy about this point you are advancing. And that's very open. Look, it's very healthy because that is notice to the lawyer. One of the best judges are those who will look you straight in the face and tell you, counsel, look, this argument, where is it really taking you to? How far do you think this argument is going to take you, or this submission? That's the best, because that way it helps you to appraise what you are doing, so that if it's not the best, then you can, augment, you can add more. So for me, it's good. Rather than maybe another judge who will not talk to you, will just let you have your way, you say, give a very long harangue, and then the judge rules. And sometimes you find out that, if my Lord had asked me about this, I could have clarified. Or maybe it's a small error, they could have corrected. So Evans, listen, overarching theme, okay, the point I'm making is that let's be a bit cautious. You see, Mr. Chikata and these judges date from way back, okay? And so we should give some margin for that relationship. We cannot afford not to give a margin for that relationship. That they date way back with him.
Okay, so there's a certain relationship there that, of course, is playing out in the court that we are seeing. Okay, now let me ask you this substantive question about the accountability question that keeps coming up. And I know this case is yet to be determined, and so I'm not asking this question based on what is yet to come, but I'm asking a general principled question about state institutions accounting to the people. So, for example, what is the best forum if you want the EC chairperson to render an account of how they've conducted an election? Is it the court or, say, Parliament, for example? Because I've heard the lawyers for the second respondent make the point that if the accountability is what you want, which Mr. Chikata argues today, then don't come to the court, go to Parliament and make hold that to account before the people's representative. What's your position on that?
Now, Evans, a lawyer should not be heard saying that at all. Okay? Let's go back to the 2012 petition. You will find in it that when Dr. Afari-Gyan mounted the box, then through cross-examination, he admitted issues about the serial numbers not being unique. So the court found, and that was a critical case. Remember, the petitioners, President Anado and Bawumia, came into court. One of their biggest areas of concern was that the pink sheets had duplicate numbers, and there were so many. So if the court had upheld the issue of duplicate serial numbers, they would have annulled most of the votes because they wanted to have over 4 million votes annulled. The point I'm making is that even though the Supreme Court didn't accede to that relief, you read the judgment, the opinions of the various judges, you find them telling the EC that no, even though we are not acceding to that request, we want you to do something about that. So in one word, we got reforms through the Supreme Court judgment, okay? So that's accountability. Apart from the serial numbers, so you see that in this last election, now the serial numbers, they had to make them unique. They added more security codes. And also in that petition, you'll find that Dr. Afari-Gyan also made a mistake in terms of the total number of votes cast. You read the opinion of Justice Doche, you find it stated there. So this time that Madame Jean Mensah also made some mistakes, you see that now we have a certain history. That Afari-Gyan made some mistakes. Madame Jean Mensah has even made more. So it tells you that, okay, Do we need to hire professionals, mathematicians to come in and help them? So I see that we will get at least some reforms in this current petition. So please, let's not make any mistake at all. Let's be eclectic in our approach. We will get some accountability in court. We can get some in the court of public opinion. We can get the rest in parliament. Let's go that way. Eclectic. Okay, use various approaches. Don't use just one. Don't put all your eggs in one basket. No.
I'm grateful that you joined us with that explanation. That's private legal practitioner Martin Kpebu. The Newsnight starts right now.